What to do if you're arrested in California. If you've been arrested or charged with a crime in California, what you don't do or what you don't know can cost you everything: your case, your record, and even your freedom. Hi, I'm Nana Knight, and I've spent over 15 years in the courtroom, first as a prosecutor and now as a board-certified criminal law specialist and a criminal defense attorney. If you need to speak with an attorney for an urgent matter, give me a call, 408-877-6177. And let's begin with why knowing what to do during and after an arrest matters so much. In California, even one criminal charge, whether it's for a DUI, domestic violence, assault, theft, or drugs, can have long-term consequences. A conviction can follow you for years. It can affect your ability to get hired, keep your job, rent an apartment, apply for loans, or even maintain your professional license. And if you're in the military or if you hold a security clearance, your career could be at serious risk. But here's the part most people don't understand. Law enforcement officers are trained to get you to talk, to cooperate, and to give them information before you realize how much that could hurt your case. And that's why what you do right after an arrest matters so much, because those decisions can either protect you or give the system more to use against you. So what should you actually do if you're arrested in California? First, stop talking. You have the right to remain silent and you need to use it. From the moment the handcuffs go on, or even earlier, you are not required to answer any questions. Not at the station, not in a car, not when they say things like just tell us your side of the story, or when they just tell you, well, we actually know what happened. We just want to hear your side. We just want to see what you have to say about this. Say nothing. Silence is a form of protection. Second, ask for a lawyer. Say the words clearly. I want to speak to an attorney. That tells the police that they're legally required to stop questioning you. And don't stop there. Don't keep talking. Don't try to explain your side, and don't assume that if you just cooperate, they're going to let you go or they're going to go easier on you. They won't. Third, unless certain exceptions apply, don't agree to any searches unless they show you a warrant. If they ask to search your car, for example, your bag, your phone, you have the right to say no. You can say, I do not consent to a search. And that one sentence can give your attorney the power to challenge anything found during an illegal search. Fourth, you have the right to know the charges and see the evidence. The state has to tell you what they're accusing you of and what they're using to build their case and convict you. That gives your attorney the opportunity to challenge the evidence, to question how it was collected, and identify where your rights may have been clearly violated. And finally, don't rush into any decisions. A lot of people think that the next step is going straight to trial, but the truth is sometimes the best move is to negotiate a dismissal or get charges reduced before you even see a courtroom. Every case is different, but the one constant is that early action matters. The sooner you get an attorney involved, the more options you will likely have. A good defense lawyer can step in before charges are even filed and make moves that change the direction of your case before it ever gets off the ground. So if you're in this situation or you think you might be soon, give me a call. We'll talk about it, we'll walk through it, and I'll help you figure out exactly where you are, where you stand, and what your next move should be. My number is 408-877-6177, and that call is confidential. If you found this video useful, make sure to check out the next video.